We have some folks still trickling in, but Judge Stein, I will hand it over to you to get us started.
Thank you so much, Shell. Good afternoon, everyone, and welcome to the second installment of the 2023 Disability Law Series on Civil Rights and Individuals with Developmental Disabilities. I'm Leslie Stein, Director of the Government Law Center and home of the Institute on Aging and Disability Law. As you saw when you logged on, this is the second program in this exciting series of 5 programs, which, as you might expect, has been organized by a number of individuals, and I'd just like to recognize a few of them. Special thanks to the members of the Aging and Disability Law Committee members, Lawrence Faulkner, Paul Keatsman, and Sheila Shea, led by our own Professor Rosemary Bailey. Also, many thanks to the GLC staff members who have handled the arrangements for this program. The topic of today's program is consent in healthcare decisions. The other programs in the series will be held on March 9th, March 30th, and April 14th, all at 1 p.m. And we hope you will join us for as many of those programs as possible. Before we move on to the program, I just want to let everyone know who is hoping to get CLE credits for today's program that 2 codes will be given both on the screen and verbally throughout the program this afternoon. So please watch out for that. We are very fortunate to have as the moderator of today's panel, Alicia Ouellette, the always amazing 18th Dean and President of Albany Law School, Albany Law School alum, class of 1994, and a scholar in the field of health law and disability rights, among other things. Dean Ouellette will introduce our exceptional group of panelists, and I will hand it over to her.
Thank you so much, Judge Stein, and welcome everyone. And welcome to all our incredible panelists. As Judge Stein said, I've written a lot in the area of bioethics and disability rights, but my career really started where this panel is today in terms of my academic career. And when I practiced, I was involved in some very difficult cases involving questions about consent for healthcare decisions. And so this is bringing me home to issues that I care deeply about. And as I got ready for today's panel and read all the developments in law that have taken place over the last decade and few years, this is an area that has really evolved in a very interesting and positive way, and you will see that we have a complex web of law and regulation that is attempting to deal with some very difficult decisions and respect the autonomy and agency of individuals with developmental disabilities and other individuals who lack capacity to make their own decisions. So with that, I'm going to actually ask each panelist to do their own introduction, starting with Robert Swidler.
Okay, hello, I'm Robert Swidler. I'm General Counsel to St. Peter's Health Partners in Albany and St. Joseph's Health in Syracuse, and I have been involved in issues of medical ethics and bioethics, including with Dean Ouellette in many areas in the past, and have written on issues about informed consent and decision-making capacity in a number of articles and book chapters. So I'm happy to be here today. I'm a little bit intimidated by the qualifications of this panel, but I'll forge on. Thank you.
Thanks, Robert. Haldan.
Thank you, Dean. My name is Haldan Blecher, and I'm a senior attorney at the Office for People with Developmental Disabilities. I work in the Bureau of Service Delivery, and my work primarily focuses around issues of consent, decision-making, and individual rights generally. I was also the principal author of New York's recent supported decision-making statute, which I think we'll be talking about, or I know that we'll be talking about. And certainly I share your feelings, Robert, that I'm also intimidated by the caliber of panelists. So I really appreciate being invited. Thank you.
Very nice, thank you. Dr. Applewhite.
Hi, thank you, Dean Ouellette. My name is Megan Applewhite. I'm I'm a clinician by training. I'm a general surgeon, specifically an endocrine surgeon, and I'm over at Albany Medical Center. Spend about half my time operating, and with that comes determining clinical capacity for patients making decisions about operations and different treatment styles. And I'll talk a little bit about that today. But on the other half of my time, I'm the director of the Alden March Bioethics Institute at Albany Med, and it's a tremendous pleasure to be able to work with my faculty here, who are a bunch of wonderful, brilliant human beings. So I am really grateful to be a part of this panel, and I'm looking forward to hearing everything that you guys have to say and maybe shedding some light on the clinical side of things.
Thanks so much for being here. And Sheila Shea.
Good afternoon, Dean. I'm Sheila Shea. I'm a 1986 graduate of the Albany Law School, and I had my first exposure to disability law at the Albany Law School Disabilities Law Clinic. And so I'm forever grateful for Albany Law School to give me a professional foundation. I'm completely privileged to be an employee and now the director of the Mental Hygiene Legal Service for the 3rd Judicial Department. MHLS is an agency of the appellate divisions of the state of New York. We have a unique mission to provide legal services and assistance to people with mental disabilities. It's an extraordinary position, and I've enjoyed endeavoring into healthcare decisions because, as you discussed, the law evolving, so has our role evolved. So thank you for inviting me today.
All right, so as everyone can see, we have a lot of expertise on the panel, and what we are going to do in terms of run of show is have each of our panelists present from their perspectives for about 15 minutes for each of our panelists, and then we will go to a series of hypotheticals of fact patterns that we'll use to have what we hope will be a really lively discussion about how the laws and the ethical issues come into play in some pretty real-to-life situations. So we will start with Robert Swidler, who's going to give us an overview on the many and complex laws involved.
Right, I was charged with giving this primer on informed consent and decision-making capacity, decisions for patients who lack capacity. Is my PowerPoint or my slides up on the screen successfully? They are, okay. So this is going to be a bit of a high-speed car chase through these issues because they are, there's a lot to talk about, and I'm going to limit my time to high-level discussion of this. We start with informed consent. This is not the statutory definition. It's partly drawn from New York statute on informed consent, Public Health Law 2805D, and partly adapted to make it more intelligible than 2805D. But informed consent is the permission voluntarily given by a patient for a medical procedure after the practitioner has disclosed the risks, benefits, and alternatives in a manner permitting the patient to make a knowledgeable evaluation. We could deconstruct this all day long. What is permission? What is voluntary? What if it's not the patient, and et cetera. But I think it really breaks down into two principal components. One is the consent part, which is the older doctrine, which is you need permission before you could do a procedure on a patient. And a newer, and by newer I mean developed in the 1950s, part of the doctrine, which is in order for that consent to be ethically and legally valid, it has to be based on information provided by the practitioner about the risks, benefits, and alternatives. Just consenting to a procedure is not valid enough if you don't know what the risks, benefits, and alternatives are. Our focus is going to be on the consent part of it. As I said, that's permission given by a patient for a medical procedure. Patients have a right not to be treated without their permission. It's not just malpractice, it's a potential battery to be treating a patient without their permission. The landmark description of this principle is by Judge Cardozo of the New York State Court of Appeals, later on the US Supreme Court. And this is cited all over the country. It was one of the landmark cases on both a predecessor to the string of right to die cases, as well as consent and informed consent. He wrote, every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. I hope I'm not scaring you, Dr. Applewhite, but that's the principle there. You need the patient's consent. And this was a surgical procedure without the patient's consent, and the doctor in the hospital was held liable. So there are exceptions to the obligation to get the patient's consent. The principal one, and the one we're focusing on today, is lack of capacity. If the patient doesn't have capacity to give consent, you got to get that consent some other way. There's also an emergency exception, but I look at that as a subset of the lack of capacity, because that comes up, it can come up in a lot of contexts, but you can most easily picture a car accident, a patient being wheeled in unconscious. There's no opportunity to get that patient's informed consent, but we need to save this patient's life. One difference between this and other lack of capacity cases is there may not be an opportunity to get anybody's consent, let alone the patient's. It's just an obligation to try to save this patient's life in an emergency when they're not able to make a decision personally. There are other exceptions. One we could hold a whole seminar on is the need to protect the public health. And you're immediately thinking about vaccination for COVID. There's a lot of lawsuits going on. We are a defendant in my system in one of them about requiring healthcare workers to get vaccinated, but it's not forcibly requiring somebody to get vaccinated. It's not involuntarily hospitalizing them and restraining them and vaccinating them. It's just consequences for not vaccinating. But there are cases where we do mandate that somebody's treated even over their kicking and screaming objection for the public health. And we've done that in maybe 15 years ago, during the tuberculosis outbreak. But that's another exception to getting patient consent. And there are instances in which prisoners can be treated over consent. So those are the principal exceptions to even getting consent. The informed part, as I said, you need to provide the risks, benefits, and alternatives. It's not just a matter of disclosure. That may be what New York law requires, but from an ethical standpoint, this is a process, not a signature or a disclosure. It really calls for a discussion between the provider and the patient, and an opportunity to ask questions and ensure that the patient has a full understanding of what they are getting themselves into. There's a number of sources of the legal requirement to obtain informed consent. In New York, the principal one is Public Health Law 2805D. And I won't go into this, but it's written in a very odd way. It's written as what are the defenses to a lawsuit for lack of informed consent. Those are rarely successful or infrequently successful because there's so many defenses to it. And it's different from a malpractice case. In a malpractice case, the claim is that the physician did not provide care that measured up to the standard of care of an ordinarily competent physician in the community. And as a result, the patient was injured. In a claim for lack of informed consent, the physician might have provided, textbook perfect care, but the patient didn't give a valid consent because they didn't get the information about what their risks were. And those risks are what injured the patient. So it's a very different kind of action, and it's not frequently successful. Let me skip ahead here. I just covered that. But we talked about how the exception to informed consent we want to focus on today is that the patient is not able to give consent. They lack capacity. So what's decision-making capacity? There are also a number of different definitions in the statutes, in the regulations, but they are basically similar. This one is from the Family Healthcare Decisions Act. It's the ability to understand the nature and consequences of proposed healthcare, including the benefits and risks of and alternatives to proposed healthcare, and to reach an informed decision. And so there are similar definitions in other statutes, like the OPWDD regs have a glossary that defines consent. It's similar to this. It gets into a little bit more detail about the consent for different kinds of decisions. There's also a similar definition in the healthcare proxy law, but it focuses on the patient's ability to understand and make a decision about healthcare. If we're talking about, there's a different concept in the Article 81 guardianship statute, which relates to the functional ability of the patient of the individual to care for themselves, which is not focused on a treatment-specific ability, a treatment-specific decision, but more of an overall ability to care for yourself. So you can easily see the significance of capacity. It determines whether the practitioner seeks consent from the patient or from somebody else. So, I mean, there could be a lot going on in these pictures, but the obvious thing is that person on the left can sit up and make a decision and they're talking to the patient. In the picture on the right, you can't talk to that patient. You got to talk to somebody else to get that decision. Now, there's a lot of variations on what capacity is. It could be very clear that this patient lacks capacity. They could be unconscious. They could be under serious anesthesia. They could be deeply intoxicated, have advanced dementia, psychosis. They could be a child, an infant, so that they don't have capacity, or have a profound intellectual disability. Or it can be less than clear, mild dementia, moderate intellectual disability. And we're going to be probing some of these less than clear scenarios in our hypotheticals today. Depression, bipolar, just bad judgment. We get a lot of doctors sort of raising the issue. This patient is making such incredibly bad judgment on this decision that I question their capacity. Or an older child maybe may or may not have capacity. So it can be clear or less than clear. It can be long-term, advanced dementia is not going away. Short-term, actually mild dementia, some patients in nursing homes have capacity in the morning and then lose it by afternoon and then have capacity the next morning. So you want to catch them when they have capacity. It could be continuous or intermittent. A patient could lack capacity for some decisions, for complex decisions and not others. And we're going to probe this too, because one of my views is that there are patients who have capacity to appoint a healthcare agent, but don't have capacity to make the underlying complex decision. So they can appoint a healthcare agent and a minute later be determined to lack capacity for purposes of consenting to a complex medical decision. This is a very important one, often overlooked. We have to treat a patient who is passive, who just accepts that they've been found to lack capacity and somebody else is making decisions, very differently from the patient who is sitting up and going, no, I'm telling you to do this. That's going to trigger more due process and more procedures and more legal rights and issues than the silent patient. How is it determined? Well, in most laws in New York, we start with a presumption that a patient has capacity, and then you have to determine it, the lack of capacity from there. There's an exception in statutes like Family Healthcare Decisions Act for a patient who has a judicial guardian under Article 81 or under 17A of the Surrogate Court Procedure Act. They don't get the benefit of that presumption. They might still qualify as having capacity. For most healthcare decisions, the determination is a bedside determination, not a judicial determination. Here again, I think if a patient objects, we trigger due process, and that's where you would need to have a judicial determination. For instance, in Rivers proceedings where a patient is refusing antipsychotic medication, they have the right to do that until there's a determination, judicial determination to override that objection. But in the ordinary case in the hospital bed, no. And I would love to see somebody write on this. I think there's a difference between kind of incoherent no, 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 and a statement of, I don't want you to do that to me. That's very, that first one, I'm not sure qualifies as a objection to the determination. So laws, I'm not familiar with any laws that specify the clinical tests, and I think Dr. Applewhite can speak to some of the clinical tests that are used, but they do speak to the qualifications of the professionals, and you need and the level of certainty has to be determined to a reasonable degree of medical certainty, and some may need a concurring determination, and they address the documentation of it. But there isn't a legal, to my knowledge, specification of what capacity tests, what clinical capacity tests have to be performed. So key examples about the laws on the determination of incapacity in the Family Healthcare Decisions Act has to be done by an attending physician to a reasonable degree of medical certainty. There needs to be a concurring decision if it's in a nursing home or if it's a decision to withdraw life-sustaining treatment. You don't need it if you're getting beneficial treatment. You don't need that concurring determination. And there's a broad range of practitioners who can provide that concurring determination. It does require special qualifications if the patient lacks capacity due to mental illness or developmental disability. In contrast, if you look, for instance, at the Healthcare Decisions Act for people with intellectual or developmental disabilities in Surrogate Court 1750B, similar to begin with, initial determination by an attending physician to a reasonable degree of medical certainty, similar with different language, but also requires a consulting determination and requires highly specialized qualifications for that person who makes the determination. I think the concern is primarily that there are patients who have capacity that's going to be undervalued by practitioners not qualified in this area, but it may also be a concern in the other direction as well. So, okay, decisions for patients who lack capacity. And I'm thinking I've got about 2 minutes. Is that about right? Something like that. So what I think is important and often overlooked is the first place we would look is for a patient's prior decision. If that patient previously had capacity and made a decision, we don't have to go any further, either by sitting up in bed or an advance directive. And this is actually enshrined it's hidden somewhere, buried in the Family Healthcare Decisions Act. It says in here, nothing in this article obligates you to get a surrogate if the patient already made this decision in advance, either orally or in writing, or if it's a decision about life-sustaining treatment, they need some witnessing. So we sort of have our own little mini living will law there. But if we don't have a decision in advance, the next step is, did this patient appoint a healthcare agent? And if they did, then we can get that decision from the healthcare agent. If they did not, then for the general patient population, you look to the Family Healthcare Decisions Act, and that empowers a family member or a close friend to make a healthcare decision when the patient lacks capacity, didn't previously decide, didn't appoint a healthcare agent. But it doesn't apply to people receiving OPWDD services or who are transferred from a mental health facility. They have their own laws and regs. This is the priority list under the Family Healthcare Decisions Act. Guardian, if there is one, most people don't have that, or a spouse, adult son or daughter, a parent, brother or sister, and I'm not going into disputes and resolution and so forth. It also has a process to getting a decision for an isolated patient. I think what I want to do is just end with this slide so we can have others get into the issues. And what I think this is a helpful way to visualize this: degrees of ethically authoritative consent. Well, if the patient's sitting up in bed and making the decision, that's the gold standard. If they're not, the next to gold standard is that they previously were sitting up in bed and made the decision and now lack capacity. If that's not available, healthcare agent. If that's not available, Family Healthcare Decisions Act surrogate, or for somebody with developmental disabilities, it's the regulatory surrogate under 633(11), or 10 or 11 if it's depending on if it's a life-sustaining treatment. And then the Family Healthcare Decisions Act has a process for isolated patients or somebody with developmental disabilities. There would need to be a surrogate decision-making committee making the decision. I lied. The last thing I want to point to, I know Alden will be speaking at length about about the supported decision-making statute. In my conception, it falls here in this continuum. This is a patient who has some question about capacity, but with supported decision-making, we can accept a decision from that patient themselves. So I put it here before we get to the incapable patient. I'm not sure I perceive this as a gap for the general patient population, but it is, I think we're going to find it is helpful and does address a gap for decisions for people with intellectual and developmental disabilities. I'd like to talk more, got to wrap it up. So thank you. I hope that was helpful.
It's great and right on time. I think
Great.
we're in code now. Yeah.
Yes. Hello. I'm going to share my screen. Thank you, Robert, first for that. I am going to share my screen. The CLE code word for those of you seeking CLE credit is stigma. That's stigma, STIGMA. If you're joining us on the computer, you'll see it on your screen. Again, that is stigma, STIGMA. Thank you.
Thank you. And now we're going to hear a little bit more about that bedside clinical determinations and all of this from our resident physician, so Dr. Applewhite.
Thanks. I don't have a PowerPoint. I thought I'd just sort of talk about generally how we approach patients when we're seeking informed consent or when we're proposing a particular therapy, and kind of how we determine capacity. So this is something that we do all the time, and there are very particular tools that can be utilized to assess capacity. They're infrequently needed. The two main tools that are out there that I'll just sort of talk about first, just so that you have them, in the back of your minds, is the mini mental status exam. It doesn't require any formal training. It takes about 25 minutes to do, and it's easy. The trouble is that it doesn't address any of the 4 decision-making abilities that determining capacity requires, but it does give you sort of a global sense of their understanding. And it's not validated in patients with mental illness. And so it's, while the easiest to use and the most universally usable, because it doesn't require any formal training, it is not as good in those individuals who have mental illness, and it doesn't directly address understanding, expressing a choice, appreciation, and reasoning, which we'll get into in a minute. The second one, which is better and sort of usually seen as the most useful clinically, is the MacArthur Competence Assessment Tool for treatment. It basically provides scores in each of these 4 core decision-making abilities that we say that patients should have in order to determine that they have clinical capacity. So I'll outline those now. So basically, when we're approaching a patient to determine whether or not we're going to operate on them, if this is something that they want, or if it is a particular intervention like a catheterization, if it is any kind of medication they're administering that needs particular review of the risks and benefits. You go to the bedside and you talk to them and get a global sense of what they think is going on, right? What do they understand about the problem that they have? What is the meaning of the information? Do they understand what their diagnosis is? Do they understand the options for treatment, and educating them in this way, the risks of the various options and things like that? So basic facts that are universal for anyone who has their diagnosis that is going to proceed forward with a particular type of treatment. They need to express then appreciation of those facts. And what that means is they understand the facts of the matter and they appreciate how it applies to them. So effectively to say, yes, I understand that the risk to most people of, say, injury to the recurrent laryngeal nerve during a thyroid surgery is about 1%. To me, my risk is 5 times higher because I've had 2 previous neck operations and there's a lot of scar tissue. So you understand the basic risk for this procedure, and then you understand and appreciate, which is the second component, how that directly applies to you in your situation. You have to prove that the patient can reason through, and that is to build their ability to express that they can compare the options of operative intervention versus non-operative intervention versus sort of watchful waiting, discuss the risks and benefits, and then apply all those things to themselves. So to say, of my given options, which one is the most reasonable for me and why? And this is kind of a catch, right? Because physicians also, we sort of have this ego where we think that if the patient doesn't make the decision that we would make, that clearly they don't have capacity, right? Like, he said he doesn't want to have his leg amputated, but it'll be okay. And so I think that he probably just doesn't know that. So we're going to go ahead and do it because it's obviously the right thing to do, right? So we sort of get it. We have to sort of retrain ourselves to think just because somebody doesn't share our same values does not mean that they don't have capacity. And this is something that we routinely need to remind ourselves of, if someone is not making the decision that we would make or that we would make for one of our families or loved ones, that it doesn't mean they lack capacity. And that's at the reasoning part, because that's where values become sort of front and center. And then finally, they have to be able to express a choice. They have to be able to in some way communicate a choice, which for patients with disabilities puts an onus on us to be able to facilitate that communication and be able to think outside the box necessarily, if they're not just going to say it out loud to me in very clear language, how then I can elicit that choice. Because because they cannot communicate necessarily in a way that I'm used to communicating, or that most people can communicate, does not mean that they cannot express a preference. So taking a bigger mindset about how patients communicate best is the most important part of the fourth decision-making ability, which is expressing a choice. So the good part about the MacArthur Competence Assessment tool for treatment is that it will give you a score in each of these 4 categories that we've just discussed. And then you can, and it is validated for those individuals who have mental illnesses, which makes it different from the mini mental status exam. And so it's a very clinically useful tool. The trouble with this MacArthur test is that it requires a certain amount of training and formal sort of training to learn how to use it, to learn how to score it, and to learn how to apply it. Although they say that it's quick and easy, I think one extra step is all that it takes to sort of turn some people away from, you know, doing going the extra mile. So I guess what I'll say is most patients pretty much declare themselves early on whether or not they're going to be able to make a decision that is of clear mind, right? If they have capacity to make a decision. What becomes really interesting to me is when they have capacity to make certain decisions, but not other decisions. And Professor Swidler just pointed this out, right? Like you can have the ability to say, I want this person to be my healthcare agent, but not necessarily say I want to have this operation, right? Or I don't want to have this operation. You can say, I want to be able to have the orange Jello, right? But you can't necessarily be able to say, you know, I don't wish to have those antibiotics. I'm okay, right? So there are certain, and this is where the gray area comes in. And one thing that I'll point out, which I think is really valuable, is that we frequently in the hospital phone a friend, right? Although the onus does fall on the attending physician, we can share that sort of responsibility. And we don't always call the psychiatrists, although we can. Sometimes we'll call a social worker over to see if there are other sort of family members that are around that we can sort of have in the room, not necessarily to make the decision, but to sort of make the patient feel more comfortable, maybe translate some of the things that we're saying into a language that they understand easier. And I'm not speaking about different languages, I'm just speaking about medicalese in general, right? Which is really difficult sometimes for people when they're ill to translate on their own. We phone a friend in bioethics all the time. You know, we call consults all the time just to help with communication and sort of patient understanding. It's another voice, it's another set of ears, it's another mind to sort of think about problems in patients who may have a hard time making decisions on their own, or who are not sure if they really understand the proposed therapies. So Professor Swidler, I loved how you pointed out 2 of the very topics that I just sort of wanted to touch on. One of which is emergency situations. And this is an interesting one that I feel very, very passionately about, and that is suicide attempts when we get them in the trauma setting. So when we have someone roll into the trauma bay who has a knife coming out of their belly, and they look at me and they say, I don't want your help. I'm 80 years old. My wife died 6 months ago. All my friends are dead. My kids are good. They're gone. They've got their own grandkids. I've lived a long, healthy life and I'm lonely. Please don't help me. Right? And he gets it, right? Like you can say he has capacity, right? You could think that, you can consider that. It doesn't seem outrageous. He's not septic yet, you know, which could then, you know, sort of influence how he's thinking and his ability to clearly sort of a bowel injury or whatever he's got. But this is one thing, is in emergency or in urgent situations, particularly in patients with debilitating mental illness, you could say, seems like he has capacity, although there is a school of thought that anyone who attempts suicide necessarily lacks capacity. That's not believed universally by everyone. So those are tricky situations. And that's something that I could talk about a lot because I think it's very interesting. And certainly there is no world where we don't treat those patients because the risk is too great that you decide not to treat someone and you should have. So the risk is too great. We will always treat those patients. The bar would be far too high that to be able to reach to say, yes, they have capacity. No, we're not going to treat them. But it is a really interesting setting where we do treat over objection. Another sort of category that Robert talked about as well is the incarcerated patient population. And we think about, at least in the surgery world, feeding over objection when it gets to hunger strikes to the point where they've been fed by tube feeds through nasogastric tubes, and then down the line ultimately decide that the infirmary doc decides that they are having end organ damage. They cannot have these feeding tubes anymore. They need to have a gastric tube put in. Coming to the hospital because of our contract with the New York State Department of Corrections, saying we have a court order that you'll put in this feeding tube. But I don't want to put in the feeding tube because I'm looking at this person saying, I don't want this operation, right? Or I say, okay, I'll put it in. But then the anesthesiologist says, no way, right? So there has to be buy-in from a lot of different sort of parts of the care team in order to treat over objection in someone who, these are both sort of in the gray area of capacity. So I guess that's what I'll say. The other thing to think about for us when we're doing this in the day-to-day is that making a capacity judgment is fluid, right? So if it is not an emergency situation or if it's not an urgently necessary intervention, we do everything we can to treat whatever is limiting their capacity so that then they can make a clear decision, right? And so do what you can to reverse the delirium, surround them with things that are familiar to them, put up pictures of their family. Some people, it was amazing to me when I first started medical school, when I saw patients in the ICU or elderly patients on the floor who were totally with it when they came into the hospital. And then as their hospital course progressed, they got more and more confused. And it made no sense to me that this should be the case. I didn't understand it at all. And to be honest, I still don't totally get it, right? I think our grip on sort of reality maybe loosens a little bit when we have things that are unfamiliar around us, when we are aging, our family, our bed, our normal smells, our normal foods. So sort of reminding people, so doing what we can, I guess what I'm saying is in the sense of, delirium limiting capacity to ground people and to cause, whatever familiar senses they can to sort of reemerge so that they could ideally regain capacity or at least enough to make a decision about a particular treatment. If it can wait that long. Same with sepsis, give people antibiotics, make people, replete their fluids and things like that. Medication side effects. If somebody loses capacity because they've gotten a medication that alters their ability to make decisions, I say if as much as we can, put off decision making about big items until we've done our best to reverse whatever is limiting their capacity in the situations that we have that luxury of time. So that's my general sort of impression of things, and that's sort of how we operate on the day-to-day. And I'm happy to talk about this further with anyone and look forward to further conversation.
Thank you. So interesting and tough what you do. So next we will hear from Sheila Shea. Go ahead, Sheila.
Thank you. I'm going to build upon where Professor Swidler started with the overview of healthcare decision-making statutes. And my particular focus will be on the Surrogate Court Procedure Act 1750B statute that's governing healthcare decisions for people with intellectual and developmental disabilities. Next slide, please. The content here is designed to perhaps explain, if I can, why we have different statutes that govern healthcare decision-making. And it's sometimes helpful to put this in historical context. And historically, people with developmental disabilities were subjected to terrible treatment, abuse, experimentation. I think this history is well known to us. It's tragic. Patients were undertreated, in my opinion, due to bias that people with developmental disabilities had a diminished quality of life, or overtreated because of the restrictions in the common law. I wanted to just refer you, when you have an opportunity, we have written materials that accompany the presentation today. And my colleague, my retired colleague, Christy Coe, who worked for the Mental Hygiene Legal Service, wrote a very thoughtful article that I asked be included in the materials. And you'll see it beyond being mortal, safeguarding the rights of people with developmental disabilities to efficacious treatment and dignity at the end of life. And just I wanted to highlight one comment that Ms. Coe made in her article. The Healthcare Decisions Act, Surrogates Court Procedure Act, Section 1750B, was intended to prevent care from being forced upon a person, causing suffering. However, there was also a countervailing consideration that treatment might be arbitrarily withheld from a person with a developmental disability due to their perceived diminished quality of life. So I'd refer you to Christie's article. There's another article in the materials by Professor Natalie Chin, which is excellent in talking about crisis standards of care. And Robert and I had many conversations during the pandemic about crisis standards of care, and what we've lived through in that period of like 2020 to 2022 put such tremendous strain on healthcare systems and to population in general. And there was a very deep concern about healthcare rationing and the potential that people with disabilities and other vulnerable populations could have experienced discrimination. So those are just two thoughts that I had about the historical context. And so we can move on to the next slide. Robert touched on this, and it's so important. If a person has the ability to execute a healthcare proxy, that should be encouraged. And people with developmental disabilities have a wide range of capacity and capability, so it should not be presumed that a person with a developmental disability cannot exercise a healthcare proxy. And in this regard, I wanted to say, I've had the privilege over the last 10 years to work with Dr. Patricia Bamba and any number of initiatives around healthcare decision-making. And she always says, let's look upstream. She's really devoted an incredible amount of her thought and effort to protecting people with developmental disabilities. And she says, look upstream. If you can, let's have a healthcare proxy executed. If that proxy is executed, then we don't have to resort to the surrogate decision-making statutes that fill gaps, such as the FHCDA. And if there is a healthcare agent, that agent can make healthcare decisions. If there is no agent, however, that's where we need to address other mechanisms to fill the gaps. So next slide, please. The Healthcare Decisions Making Act, and which is codified at Surrogates Court Procedure Act 1750B. Remarkably to me, I was looking and preparing for today, we are 20 years approaching the 20th anniversary of the statute. This statute preceded the enactment of the Family Healthcare Decisions Act, which Robert worked so tirelessly to promote the passage of the Family Healthcare Decisions Act, the general statute. This discrete statute preceded the Family Healthcare Decisions Act, and honestly, I can't. It's hard for me to believe that it has been 20 years. The statute reformed the law to relax the strict common law rules that we were working with in New York, and now legally authorized surrogates may make decisions to withhold or withdraw life-sustaining treatment for patients who lack capacity when certain procedural standards are met. Next slide, please. And I'm just going to review, Robert touched on this. So we have a list of surrogates under 1750B, and it's actually regulatory. That's where the surrogate list is found. But again, guardians are at the top of the list, but you don't have to be a legal guardian. Legally authorized surrogates include actively involved spouse, actively involved parent. The list of surrogates is here. Actively involved is a definitional term. So it's defined in the OPWDD regulations, but it's someone who has knowledge of the individual and is capable of making decisions for that person. I did want to mention too, with respect to the populations we're talking about today, there are two very important surrogates that don't apply in the general population. So we have the Consumer Advisory Board for the Willowbrook class. And many people don't appreciate this, but the Willowbrook Consent Decree remains a living document. The Willowbrook State facility on Staten Island closed in 1972. but there are, I think, 2,000 living class members, and they are so vigorously represented, and they have advocacy through the Consumer Advisory Board. And the Consumer Advisory Board is a legally authorized surrogate under our state law. And the surrogate decision-making committees are an administrative body. They provided an alternative mechanism to provide consent for treatment when a patient lacks capacity. And this surrogate decision-making committee model in New York is quite unique. It dates back to 1985. They do a fabulous job for people who do not have anyone else to make a decision for them. And the authority of the SDM panels to make life-sustaining treatment was added to this through the 1750B codification. So those are two specific bodies that can provide consent that are unique to this population that we're talking about with respect to life-sustaining treatment. Thank you. We can move on. One of the things that I think is quite important about 1750B, not only did it create a statutory mechanism for a surrogate to make a decision to withhold or withdraw life-sustaining treatment, but it affirmatively codified the requirement that a surrogate advocate for efficacious treatment. So I think that's a very significant aspect of the law that I often rely upon when we doing our work at the Mental Hygiene Legal Service. And then the statute codifies the best interest standard. Next slide, please. We have a definition here of life-sustaining treatment. It does include a decision to withhold or withdraw CPR. So that's codified. So the decision about a DNR order is a life-sustaining treatment decision. Next slide, please. The statute places certain responsibilities upon the physician, and the physician will determine capacity, and there must be a concurring determination. And then next slide, please. A physician and a concurring physician must also consider medical criteria. So in order for a surrogate to make an end-of-life decision, these criteria become relevant. And I have a separate slide discussing the extraordinary burden standard, but the patient, there must be evidence of a terminal condition, the person is permanently unconscious, or the individual has a medical condition other than their developmental disability that is irreversible and will continue indefinitely. And I have a couple of examples here. Next slide, please. This extraordinary burden standard is codified. There's a similar standard, is worded a little bit differently in the Family Healthcare Decisions Act, but there are two criteria that are on the screen here. I would say when in terms of the work we do at the Mental Hygiene Legal Service, we had been working with this extraordinary burden criteria even before the codification of 1750B, because this standard appeared in the former discrete do not resuscitate statute that had been codified at Article 29B of the Public Health Law. And for everyone on the participating today, really, Robert Swidler has been so instrumental in the work that has gone into codifying these various statutes, which abrogated the common law and enabled certain surrogate decision making. But this extraordinary burden standard is, we felt initially at my office that it's somewhat vague and hard to apply. I've come to think over time and in practice that the standard is flexible and beneficial, and it can be reasonably applied. So that was my comment on that. And then just moving on, and I want to quickly get to our slides so we have enough time, but there's the statute does permit artificial nutrition and hydration to be withdrawn. These are the standards that pertain to that discrete decision. And then for those of you, I think if you can move to there, maybe one more slide. Okay, yes, oversight. I did want to talk about oversight really briefly. So with respect to 1750B and the decisions for people with developmental disabilities, a decision to withhold or withdraw life-sustaining treatment will will trigger oversight. So the decision is, there's notice that emanates after the decision is made. So if a person is with a developmental disability is living in a certified bed, by that I mean a bed that's operated by the Office for People with Developmental Disabilities or licensed by that agency, the decision to withhold or withdraw life-sustaining treatment, notice of that decision will be provided to the facility director, the program where the person's receiving residential services, and the mental hygiene legal service. If the person doesn't live in that certified setting but is developmentally disabled, notice of that decision would be sent to the commissioner of the Office for People with Developmental Disabilities, and the commissioner has delegated the review function to the various regional directors. It seems onerous to explain. I mean, the practical aspect of providing notice, you might wonder how it really happens, but it does. And we've worked really hard over time with the various hospital systems and providers to allow this process to work in a way that is compassionate and respectful. These are very hard decisions, and process is hard for people who are at the bedside or people who are in the healthcare environment. Process can be hard. The perception is you're obstructing the ability to properly treat someone. We have worked really hard so this process hopefully isn't as onerous as it might otherwise appear. And let's see, I don't know if I have any additional slides. I might want to stop here. I just want to be sure that we have enough time for Haldan. There
are a couple of slides.
Okay, do I have enough time to continue?
Yeah, but one more minute.
One more minute, okay. So the notice requirements draw a distinction between withdrawing or withholding life-sustaining treatment, and there's a 48-hour period when the treatment is to be withdrawn. Often, if our office has conducted an investigation, we've made a decision, we're not going to object, we would waive this period, and that's somewhat typical for our office to do, but the statute draws this distinction in the notice requirements. And the patient should be given a notice of the decision unless the therapeutic exception applies. And that's a whole nother discussion about the therapeutic exception. And I would welcome the doctor's perspective on it, but I don't want to belabor the point right now. Mm-hmm. Next slide. Just quickly, we utilize in our system, many of you might be familiar with medical orders for life-sustaining treatment. The acronym is MOLST. I mentioned Dr. Bamba earlier. Dr. Bamba has, since the inception of the MOLST program in New York, I think going back to a pilot program in Monroe County in 1985, Dr. Bamba has been instrumental in developing something called a MOLST in New York. It's a MOLST in other jurisdictions. It's called a PULSE, the Physician's Orders for Life-Sustaining Treatment, but we utilize it very prevalently in New York. There's also an eMOLST system, so it's paperless, and the doctor's orders appear electronically. Whenever that MOLST form is used, we use, for our population, for people with developmental disabilities, we use this OPWDD checklist. And Haldan and his colleague, Eileen Zeibel has worked for years for OPWDD and healthcare decision-making initiatives. And really, Eileen has been so instrumental, and the agency itself, in developing this checklist, which is really designed, when you look at it and you have a chance to study it, it implements 1750B. It's really a checklist to make sure that the statutory requirements are being met. And it's very useful. It's a helpful tool. If you use a MOLST form for a patient with a developmental disability, this checklist is required. And I spoke earlier when you might have a surrogate decision-making committee making an end-of-life decision, and when the committee makes the decision, it's the consent provider, but we're also typically using a MOLST form to implement the doctor's orders, and this checklist is part of that process. So I think that's the end of my presentation, and that's a MOLST form. The Department of Health just changed the form. That they rolled it out in 2023. If you go to the health department website, it's going to look a little bit different. There's a lot more to be said about the rollout, and I think it could have been done a little bit better with, we need a little more communication about it, but there is a new MOST form and it's available on the Department of Health website. Thank you.
Thank you, Sheila. Now we're going to hear from Haldan on supported decision-making.
Okay, can everybody see my slides?
Yes.
Okay, great. Thank you, everybody. So Robert mentioned supported decision-making, and actually Dr. Applewhite sort of described it without naming it also, or at least a version of it. But I want to talk a little bit more about what it really is and how it fits into the context of healthcare decision-making. So generally, supported decision-making is described as a, or really only discussed as a in the context of legal guardianship as an alternative to guardianship. And it is that, it certainly is an alternative to guardianship, but it's not only that. It really is a much more broad concept, and it's something that we all do in an informal way. We all ask our friends or family members for advice when we're faced with important decisions. And really that's what supported decision-making is. Under the new law, there is a more formal version of supported decision-making, essentially just a formalization of this kind of relationship. But the law also makes room for informal supported decision-making, because that is really essentially the thing that we're trying to capture, that it's that the legislature tries to capture under this law, because it's that reliance on the people we trust that allows us to make better decisions and to make more considered decisions. And that goes for people with developmental disabilities and people with other disabilities, or people without disabilities, really everybody. But under this formal model that exists under the new law, an agreement is contemplated, a supported decision-making agreement, or an SDMA. And this agreement is essentially a contract between the individual who is making the decisions, known as the decision maker, and their chosen supporters. And these supporters are anybody that the individual trusts to help them with various decisions. Under an SDMA, essentially the decision maker decides who they want help from and in what areas of their life, and can include various levels of detail. They don't have to cover every area of their life. It can be a limited agreement that says, for instance, some people may want help with medical decision making, but really don't, they may not feel that they need help with other kinds of decision making, for instance, financial decision making, or other more, essentially more casual parts of their life. And then there are other SDMAs that might be very expansive. It might really cover a lot of areas and might have various levels of detail depending on the area. Under the New York law, there is the participation of a facilitator. And a facilitator is someone has expertise in supported decision-making and can help the decision maker basically, understand what it is that they're embarking on when pursuing an SDMA, and can help the supporters also understand their perhaps changed role under an SDMA. So where, for instance, a mother or father would have had a decision-making role in their child's life, once that child reaches the age of majority, the parents no longer have that right innately. They may under some of these other regimes, but they no longer have that decision-making right. And so if they want to participate in the SDMA as supporters, and if the decision maker chooses them, which they generally do because most people trust their parents to get advice from, a facilitator can be helpful in helping those supporters sort of reposition themselves and understand what their new responsibilities are as supporters. And I think, one of the things that always needs to be pointed out here is, under an SDMA, It is not the supporters who make decisions. It's very distinctly not a surrogate regime. It is not substitute decision-making. It is a system by which the decision maker, their own decision-making ability or capacity, their legal capacity to make decisions is preserved. And that's really, a paradigm shift, right? This is a different, a whole different category of decision-making compared to all of the surrogate decision-making regimes that we've talked about. It still fits in that general, world, in that universe. But what can be hard for people to understand is there is no, last resort person there, right? The whole purpose of this is to preserve decision-making in the individual with the disability. And who can SDM help? Well, really, as I said already, it's for anyone who wants to do it, right? Because you don't need any formal SDMA to do SDM. You can do it as informally as you want to. But particularly, at least as the law contemplated, this is primarily for people with intellectual or developmental disabilities who want or need support in various areas of their life, like signing plans of service, consenting to medical treatment, or behavioral treatment, which could include medical treatment as well, like consenting to psychotropic medications. It could also include restrictive interventions or rights limitations in the context of living in an OPWDD certified facility. Those are all things that require informed consent as well. And so supported decision-making can function as in providing help in those ways too. It can also be for routine consent, so to speak, or assent. We often in my job, I am often confronted by a lot of forms that need to be signed, right? And usually these are by third parties. A common example is a transportation company, a contractor whose role is to transport somebody from their residence to their day program, for instance. And they may require a form that a form is signed, and they may call that consent, they may call that informed consent. It exists, all those kinds of things often exist in a bit of a legal gray area. But in practical terms, if you want to get to the day program, someone's got to sign that form or the bus driver's not going to let them on the bus, right? And so there are a lot of situations in our lives that we all do this, right? We all sign a lot of forms just to get the thing that we're trying to get. And so supported decision-making can work in those contexts too. Of course, financial decisions as well, opening a bank account, signing a lease, interactions with county clerks, those kinds of things. And then a whole nother category, I think, is the idea of where someone wants to live. This isn't perhaps totally targeted to what we're discussing today, but I think it's another big category of decision-making that's always worth pointing out, and that is such an essential part of someone's life, and really an example of something that generally requires a much lower level of understanding or capacity, so to speak, to make that decision. So where someone may have a difficulty understanding a complex medical decision, they are still a great likelihood that they understand enough to describe where they would like to live and with whom. And so in that sense, supported decision-making can help people live where they want to live, and that may be outside of certified settings. So it can help get people out of certified residential settings and into more independent living arrangements. Just want to briefly touch upon a couple of things that the law specifically does. As I mentioned, the law does formally recognize supported decision-making as a less restrictive alternative to guardianship. And this is important. The formal recognition of this is important, partly because Article 81 asks or requires that less restrictive alternatives are explored before a guardianship is granted. So this provides some, very straightforward direction to a judge in those situations that at the very least, the question of supported decision-making should be addressed in those contexts. This is also somewhat applicable through case law in Article 17A. There is no statutory requirement for exploration of a less restrictive alternative, but there is a relatively robust amount of case law at this point describing or importing the statutory provisions from Article 81 onto 17A, and not every surrogate applies that, and certainly the Court of Appeals has not ruled on that. So it's not a singular rule, but it is still important in that context. And there are many surrogates who do suggest supported decision making before granting a guardianship under 17A. Robert mentioned the presumption of capacity. Also, I think something that I've talked about a lot when describing supported decision making to individuals who perhaps don't see the need for a law or didn't see the need for a law is, don't we already have a presumption of capacity under the Constitution or under these sort of negative rights? And yes, I mean, there is, if a court hasn't taken away your right to make your own decisions, then essentially you still have that right. But that, being that it's not an affirmative right, it's sort of hard to enforce that. And it's, it's not like you can't sue every doctor who doesn't let you make your own decisions, right? That's just not really a practical thing. And certainly in the many, many situations where we encounter people who don't let us make our own decisions, it is useful to have some form of enforcement tool. And so an SDMA can really be an enforcement tool. In order for that to be effective, though, there needs to be an explicit presumption of capacity to actually explore supported decision-making itself, right? It could become a cyclical problem where, if somebody's questioning your ability to even try supported decision-making. Now, it may not work, right? It may not prove to be effective for everybody. There may be people whose disabilities are so profound that they can't effectively use it. There may be people who just simply don't like the way it works and for whom it doesn't really work, but you need the opportunity. And so the law explicitly presumes that everybody has capacity to explore supported decision-making. And there's no real explicit capacity standard in the law, except that they have to do so voluntarily, and they have to have some understanding that they're entering into an agreement with their supporters, which of course is a very low standard. I would argue even lower than the healthcare proxy standard, which as Robert mentioned, was also quite a low standard. As I mentioned before, the New York law uses this facilitation model, which comes as a result of a 6-year pilot program that was in New York that ended last year. And it's the first law in the nation that considers facilitation as an essential part of this, but I won't go too far into that. The really important thing, though, is that when a supported decision-making agreement is formal in that it is written and it complies with the requirements of the statute and it has been facilitated, the law then creates obligations on third parties to honor and recognize decisions made in accordance with those facilitated supported decision-making agreements. So what that really means is that that bus driver or that doctor or that landlord or bank now has to honor the decision of the individual, as long as that individual has gone through this facilitation process and has created this SDMA. Now, there are some exceptions to that, and there are certainly some consideration to professional obligations of for instance, healthcare practitioners. But essentially, there is now a new obligation on third parties that they can't, again, it sort of alters some of the common law and alters some of the other statutory provisions that would set standards for capacity. Capacity now has to be viewed in the context of an SDMA in those circumstances. And that really, I think the best way to think about that is that the SDMA is essentially an accommodation in those circumstances, right? The way that one wouldn't ask someone with a hearing impairment one wouldn't judge their capacity without an accommodation so that they could understand what was being said, right? For instance, ASL or something like that, or any physical disability that required a physical accommodation, one wouldn't judge someone's capacity without providing that accommodation. Similarly, an SDMA for somebody who has gone through that process should be viewed as an accommodation that essentially changes the lens by which capacity can be viewed through. And I think some of the hypotheticals will help illustrate that a little bit. Importantly, those obligations are mirrored with liability protections, some slight increases or changes to the liability protections offered to third parties, right? Because we're changing the standard by which those third parties are now making decisions, we also have to recognize that they may have professional risk or, for instance, medical malpractice risk, et cetera. I mentioned this also, the statute still makes room for informal supported decision-making, and there are a whole lot of things that the statute offers as benefits, so to speak, for using supported decision-making even informally, and I won't go into all the list, but it's important to say that what you don't get with informal SDM is those third-party obligations and the corresponding liability protections for the third parties. The teeth of the law, as I see it. So you take some of the teeth away, there are still benefits. The law, I should mention, will become, has passed and been signed by the governor, thankfully, but it doesn't go into effect until 90 days after the Office for People with Developmental Disabilities promulgates regulations implementing facilitation services particularly. And those regulations will be proposed this spring or summer, and so by the fall, the law should be in full effect. I just want to quickly, with the remaining time, just, I think we've already talked about this, but I think it can be useful to just reiterate that supported decision-making is on one side of the spectrum and substituted decision-making is on another side of the spectrum. And of course, there's a lot of gray area in between. But it's really important to not view supported decision-making simply as another way to substitute someone's decision-making ability or their legal capacity, so to speak. It's a way to preserve their legal capacity. That is their capacity to make decisions, not necessarily their capacity to understand a specific decision, right? We've talked about some of these other, what are substituted decision-making, what are examples of that? And we've talked about most of these. I will mention, though, the OPWDD regulations that Robert mentioned that sit at 14 NYC-RR 63311. Those allow for family members who are actively involved, the way that, Sheila mentioned this in the context of 1750B, but our regs also allow for those same kinds of cascading lists of surrogates to make decisions on behalf of their loved ones in certain circumstances that may, in some cases, be outside of the scope of 1750B. 633-16 particularly allows for people to make those decisions in the context of behavioral treatment. And then, of course, advanced directives. And I'll end with this slide, which I think is just always useful and sort of mirrors Robert's slide to some degree, right? When we're talking about the span of protection to autonomy, obviously off of this slide to the right is somebody making their own decisions, right? And perhaps I should add that bubble because I think shouldn't forget that. But if we're talking about some tools for people who at least need some level of assistance in making their own decisions, supported decision making is certainly, I agree with you, Robert, it's the best we've got in terms of preserving autonomy. It's not perfect. It doesn't totally preserve someone's autonomy in every circumstance, but it goes pretty far in doing so. And on the other side of that, I would say, is guardianship. Now, sometimes these bubbles sit very close to one another, right? There are a lot of guardians who incorporate principles of supported decision-making and other things. And so really, don't take a particularly paternalist or protectionist perspective. But they certainly do have the right under the law to do so if that's what they, intend. And in between, there are healthcare proxies. There's the surrogate decision-making committee, as Sheila mentioned. There are the various healthcare surrogate statutes, or OPWDD regulations. And I also put in this, in quotes, the personal ombudsman model, which is something we don't have in the United States, as far as I know. But they have in Switzerland and in Sweden. I think Sweden is the one that employs this the most, that looks a little bit like supported decision-making, but doesn't involve a state employee who sort of has essentially a kind of a supporter role. It's a little bit like supported decision-making. It's not really something that we totally have here. But so that's my last slide. I did want to just mention, since I mentioned it in the beginning, that Dr. Applewhite mentioned something earlier that I think is really important. And I was really glad to hear the phone a friend. And you said that you invited family members or friends of the patient into the room to make them more comfortable, not necessarily to make decisions for them. That's really exactly what informal supported decision-making is, right? Because you're saying that while someone may not be able to communicate totally on their own, or may have trouble communicating, or may have trouble communicating with someone that they don't know, the unfamiliar setting, et cetera, just simply bringing someone that they trust into the room can go a long way towards allowing them to make their own decisions. And you know, there are lots of really practical examples of that, of course, like interpretation, but it doesn't have to be that practical. I think that when we all think about this emotionally, we all know that having a loved one in the room in a doctor's office feels good when we're scared. So, and when we're scared, we don't necessarily make the best decisions, or we don't feel confident about our decisions. And so supported decision-making, that's really what supported decision-making is, just a little bit from a more bird's eye view perspective. So hopefully that gives some context for some of the questions in our hypothetical.
Thank you. And I am eager to get to the hypotheticals. We have one question in the Q&A that's directly to you, Haldan. If third parties still decline to observe the SDMA, what agencies would be appropriate to seek assistance?
If third parties still, right. So this is a hard question. I think it really depends on the context, right? Our agency may be able to help with that. Mental Hygiene Legal Service may be able to help with that, depending on the context. Right, it really depends on what the decision is and what's being denied. I think there's also the Commission on Human Rights. There isn't a new cause of action in the statute, and this was certainly the subject of some debate when we were writing the statute, whether there should be a cause of action. We didn't want to make this a sort of a new forum for litigation, so I think it remains to be seen exactly how that will work. But hopefully the tool itself, the agreement when presented, and the citation and the supporters and the sort of the supporter participation will also go a long way towards convincing potentially obstinate third parties who are scared or themselves about liability, or who may have their own biases, or just simply are unfamiliar. I think having a team that is in agreement and describing what they have been taught by a facilitator, what to say, that hopefully that gets a long way, and that through some, at least some sort of negotiation or some discussion, that eventually that will be able to, that will iron itself out. But I think that there probably will need to be assistance in some situations, and OPWDD certainly will help where we can when appropriate.
Thank you. So I think we are going to get another code for CLE purposes now.
Yes, for those of you who are seeking CLE credit, your second code word is support. That is support, SUPPORT. You should see that on the screen. Again, the CLE code word is support.
All right, thank you. Now we're going to turn to some hypotheticals. We've gotten a lot of information, and now we're going to try to put it into action. So the hypotheticals are in your materials. We may be able to get them up on the screen as well. I'll give a brief overview of them. I won't give all the details, and then we'll start our discussion. So we're going to first start with GR, who is a 28-year-old man with autism spectrum condition, mild to moderate intellectual disability, and impaired communication. He lived at home with mom until age 21, and currently resides in an OPWDD certified residential alternative, where he lives with 3 other individuals. His mom does not want to be involved in medical decision-making, and he has no legal guardian or other family. He does have a close friend, and he has relationships with some of the staff, including someone who has acted as an advocate for him. He's experiencing some tooth pain in his molars and some other related conditions, and he needs dental treatment. The dentist refuses to provide care until the consent form is signed. The dentist, it's unclear whether she would accept GR's signature. So our first question, and I guess I'll direct it to Sheila to start, is who's authorized to provide consent in this scenario?
I'll start, Dean. Yes, I think under the fact pattern, I would say the question is whether George can provide his own consent. We may not have enough information to know exactly how to answer that question, but that should be our starting point. You know, can George provide his own consent? I don't know, Haldan, would you disagree with that? I think that.
No, I wouldn't. I think that's exactly right. And I think what makes this hypothetical tricky is that there isn't a clear medical treatment being proposed, right? There's the facts say that he has tooth pain and perhaps he needs those teeth pulled, but we don't know. And I think one of the tricky things under OPWDD's regulations is that if there's not a quote unquote professional medical treatment required, or what's more commonly described as a major medical treatment, something that essentially is invasive or could cause harm, or for which informed consent is required by law, then that's not really a situation where the surrogates can make a decision. It's what we would describe as routine consent. I think the other thing that makes this hypothetical tricky is that this is a sort of a pre-consent form, because there's no proposed treatment, and this is sort of like just to get someone in the door. You know, they're being asked to sign a consent based on what may happen, and it's not uncommon, particularly among dentists, that you know, you sort of go in and then you may need to perform a procedure once you get in there, and so there's you know, patients are asked to sign these sort of broad consent forms. The problem is that until you know what the treatment is, it's not clear who could provide surrogate consent if George couldn't provide it himself. So.
Sure. Robert or Megan, any comments on this? If George isn't able to provide consent for treatment, when does the authority of a surrogate begin? How would this proceed?
Did you say that he has a friend? There's one friend that he's close with. I wonder if I would bring the friend in, if I'm the dentist, if I bring the friend in and just say, listen, with this kind of a situation, we don't always know what direction it'll go in. It might be that I go in and examine him and it looks all right. It just needs a deep cleaning, right? And if that's the case, you know, do you think that's a reasonable thing for him? I could talk about with him. They could sort of, because my guess is that because he has a moderate learning disability and he has communication troubles, but isn't unable to communicate, maybe the friend would know how to best communicate that. Say, on the other end of the spectrum, we may need to pull teeth, and doing that would be painful, and it would require, you know, post-operative visits and all these other things. And so sort of explaining, in a sense, like best case, worst case, and the likelihood that it'll fall somewhere in the middle, and whether or not he's able to appreciate the risks and the benefits of the most likely intervention and probably the most extreme intervention as communicated, you know, with the support of his friend, is what I'd probably do to start.
So this is a case where I would look at the potential to appoint a healthcare agent. So this sounds like a person who might not have the capacity to consent to the root canal or some real invasive dental procedure, but might have the capacity to designate their friend and thereby give them the legal authority to make that decision for them. The problem with the healthcare proxy is that we needed a formal determination of incapacity, and that gets into issues of whether that travels to the dentist's office or not. But I would look at that, and certainly with the appointment of somebody as a healthcare agent, then the dentist has the opportunity to get both the consent of the agent and the signed consent of the patient and say, hey, you know, one of these is valid. So sounds like a practical approach for that.
Mhm. Could I comment on Robert's observation, Dean? I think it's a terrific response, Robert, and I would also, I just want to mention, since George is living in an IRA, it's quite common for people who are living in certified settings to have a healthcare proxy executed in the community, which could then be used to facilitate medical treatment. I just wanted to mention that there are special witnessing requirements under the public health law for when a healthcare proxy is executed for someone living in a community residence, either licensed or operated by OMH or OPWDD. And it's a pitfall, I have to say. The witnessing requirements can be they're not understood, and if it's not properly witnessed, it will jeopardize the proxy. But the citation is Public Health Law Section 2981, and the witness must be one person who's not affiliated with the facility, and at least one witness shall be a physician, nurse practitioner, physician assistant, or clinical psychologist, and they have to have special credentials. But that's a recent chapter amendment to Article 29C to expand the list of professionals who could be the witness. So just something to think about. But I think that's the answer. That's the very good observation, Robert. I concur.
So there is a question from the audience about who would determine if George has capacity. Would it be someone at the group home? Would it be the dentist? How would that work in this situation?
I mean, I think I would say that functionally it would be the dentist, right? I mean, it says Dr. Applewhite described that this is a bedside decision, and really it functionally is that way, even if perhaps there was another system by which someone should be evaluated, right? I mean, obviously OPWDD residents are often evaluated beforehand for various reasons, and so those predeterminations of capacity might play in to a clinician's own capacity determination. But ultimately, since it's the clinician that needs to perform the procedure, they're the one that needs to capture consent, and therefore they're the one that needs to determine whether they feel there's capacity. But obviously the third question gets at how supported decision making might change that relationship. And certainly the law would potentially change those circumstances, right? Because the situation where the clinician's standard by which they judge capacity would be slightly different in the context of a supported decision-making agreement, right? And Dr. Applewhite pointed this out, that George in this situation can communicate verbally with people he knows and trusts, and that he uses other modes of communication like stimming and conventional gesturing. So if you had other people involved, for instance, supporters under a supported decision-making agreement, that they could interpret for George in such a way that would allow him to make decisions and to demonstrate his appreciation, for instance, of the risks. I mean, the other thing, though, that I would want to mention in this situation, and I think it applies in any situation where these sort of pre-consent forms are required, and it goes to what Dr. Applewhite was saying as well. I think that oftentimes what I do when I'm confronted with these situations for people who receive services from OPWDD is I ask the clinician to essentially separate the consent form, right? To not ask for consent in order to evaluate, because I think that's what, in the absence of a healthcare proxy, it's very hard for us to use any surrogate or substitute regime until you know what needs to be done, and unless you can evaluate properly, then you can't ask, for instance, the SDMC if there's no if there's no one else or a family member, you can't really ask them. So I would ask that please see this patient, figure out what's going on, but don't pull the teeth if that's what you find is necessary, and come back for consent at that point.
Thank you. So I want to change the hypothetical up a little bit. If we consider a different variation where we're talking about Emily, who is a 95-year-old woman who had been a lawyer for many years. Now she has Alzheimer's disease and related dementia and impaired communication ability. She also lives in a nursing home. She also, like George, has no involved relatives, but has a close friend who she can rely on in some ways. And she's close to some of the nursing home staff and members who have long cared for her. Emily also has dental issues and is going to the same dentist. Same dentist was the same form blind. So how does that change our analysis of our answers to our questions about who has capacity? And Robert, I was going to throw that to you.
Yeah. Can I share a screen for a second? It's a slide I showed before. I cannot share screen while other participants share. Okay, hold on a second.
You should be able to now.
Thank you very much. So I showed this when I did the presentation before. This is just a handy way to think through the options here. So first of all, does Emily have capacity? Well, she is presumed to have capacity, but I think we're dealing with a dentist that is saying, I don't think she can decide this herself, so I'm not going to accept that decision from her. So we don't yet have supported decision-making in this context because I don't think there are regs out there that apply to this context. Of course, you could always turn to a friend, but the dentist is still going to say, no, I'm not accepting that decision, even if she consulted her friend. Did she have a prior instruction? We can't make that up in this hypothetical. Did she appoint a healthcare agent? No, she didn't yet. Could she? Here again, I think that she potentially could, and that might be a solution to it, except for the issue of the determination of incapacity. But here again, the dentist may say, oh, so you got a healthcare proxy? All right, I'll take the decision from that healthcare agent. That might be good enough to get the dentist to accept it. If not, here, those of us who are fans of the Family Healthcare Decisions Act, you picked a weak point of it because it applies in hospitals, nursing homes, and for hospice decisions. It does not, it should, but does not yet apply in other settings like doctor's offices, or does not literally apply in doctor's offices, dental offices, and surge centers, other settings. Task Force on Life and the Law proposed extending it to those settings. The legislature hasn't done that yet. And they're all hung up on the issue of how do we get a determination of incapacity in a dentist's office, that kind of thing. But what we're seeing in the wild is that clinicians will often accept the decision of the person who would be the Family Healthcare Decisions Act surrogate, even in contexts where it doesn't literally apply. Or you could also gimmick this by saying, hey, go to the dental clinic that is part of the hospital operated dental clinic. Or you could go to the hospital and get an appointment of a surrogate and then tell the dentist, well, this person was appointed during that kind of care. I think what you don't want to do is, well, this isn't if the Family Healthcare Decisions Act applied, her close friend could qualify as the decision maker under that surrogate priority list. I don't think the isolated patient issue is relevant to her, and I don't think you would want to go to the trouble of a judicial proceeding for an Article 81 guardian just to get a dental procedure. That seems to me to be overkill, or to convene a surrogate decision-making committee is not applicable to this person. So I think the solutions here are either in the appointment of the healthcare agent or talking the dentist into accepting the Family Healthcare Decisions Act surrogate. And when we talk in a few weeks about legislative initiatives, that's one I'll be raising, that we should extend Family Healthcare Decisions Act to these non-hospital settings.
Thanks. So some differences when we're talking about George versus Emily. Is there any sort of policy or ethical rationale for the differences in the treatment?
Dean, I could lead on or try to answer to that. when I started my presentation today, I had the slide on the historical context that were underlying the enactment of Surrogates Court Procedure Act 1750B, and I feel as though those criteria, as I mentioned, discussed in the articles in the material, explain, in my opinion, why we have these differing standards and the policy judgments behind them. We're dealing with vulnerable populations, and that's why, again, in my opinion, oversight is built into these surrogate healthcare decision-making statutes.
I would only add that at least as far as supported decision-making in this context is concerned, I think that Emily could use supported decision-making and certainly could use the informal version of it, but even could use a sort of a semi-formal version of it under the law. The law does not, it doesn't make it exclusively available to people with intellectual or developmental disabilities. However, those teeth of the law, at least currently or in the foreseeable future, will only be available to people with intellectual and developmental disabilities. And the context there, the historical context there, is very much just based on essentially the social science behind supported decision-making. There just isn't there isn't a wealth of research that has gone into how supported decision-making works for older adults or people with cognitive decline or people with psychosocial disabilities. Most of the research, not all, but most of the research has been for the developmentally disabled population. And so we sort of know how supported decision-making works, or how it should work and how it works best for that population. And that's why the law was limited, at least to a certain extent. That being said, Emily could use supported decision-making, and much like the dentist may accept the Family Healthcare Decisions Act surrogates, by using supported decision-making, that may give the dentist more confidence that the decision is a considered one, and either allow Emily to make that decision for herself in the context of, of the supporters and what they are describing, or allow one of the supporters, who may also be a potential surrogate, to act.
Thanks. It's interesting, your response on that, Haldan. I was struck when you said the supported decision-making acts as an accommodation, right? And Emily certainly needs an accommodation just as much as George. So
yeah,
something to think about. Why don't we move to the next hypothetical? And we now have Lisa, who is a 65-year-old woman with Down syndrome who lives in an individualized residential alternative. Lisa had a good active life, and she is close to her younger sister, who has acted as her advocate. Her health started declining at age 60, and by age 65, Lisa withdrew from activities, was no longer speaking, and started really having fairly severe issues. She was diagnosed with end-stage Alzheimer's disease, and had significant physical decline. It became difficult to feed Lisa, and she lost all interest in eating. So decisions need to be made about whether Lisa's treatment will be aggressive or palliative in nature. So summarizing the hypothetical, with the first question being, who is authorized to provide consent in this case? I can call on someone, or does someone want to volunteer?
I'll volunteer.
Okay, go ahead, Sheila.
So I think this fact pattern really raises serious issues about capacity. And since Lisa is residing in a facility that's licensed or operated by OPWDD, there is a surrogate list. We've talked about it in this program, but it's promulgated at 6/33/11. And the fact pattern says that there's an active, I construe a younger sister is actively involved based upon the facts and as I understand the regulatory structure. So I would say certainly Lisa, if capable, should be the person making decisions. If she's not capable, her sister is a legally authorized surrogate under the OPWDD regulatory scheme.
All right.
Agreed.
I would only add that she would also likely, her sister, be an authorized surrogate under 1750B in the case of an end of life decision. And obviously the regulatory scheme and 1750B are connected, but important to point out that as well, that if that's, what happened.
So when does the sister, does everyone agrees that the sister is probably the surrogate here? When does she get to make these decisions, and can she, does Lisa have to be hospitalized, or can decisions be made outside of the hospital? Robert?
Well, I would say upon the determination of incapacity by the staff at the facility. So
I would concur with that, Robert, and also this is an opportunity to mention, Robert mentioned before that the Family Healthcare Decisions Act has specific requirements about where the law can be applied. There's a distinction with the Surrogates Court Procedure Act 1750B statute. It's not setting specific, so it can be applied in the community, and that certainly has been a benefit to our clients.
agreed.
Yeah, I agree.
One reason I was hesitant to answer there, Dean Wood, is that in looking over 633, 10 or 11, I forget which one, I think it's 11 on consent to major medical procedures. It has an interesting provision that I don't remember focusing on before. It says if incapacity is unclear, then you need to go through this process of determining incapacity with a specialist. But it doesn't really speak to when incapacity is clear. And I'm wondering, is that an area where those are treated differently, so you can assume incapacity in some instances without going through the determination process? To me, that may make sense sometimes, because we think it makes no sense to do a determination if somebody is unconscious. You don't need to call in a specialist to determine their capacity. But I just never appreciated that distinction in the OPWDD regs before. Is that significant?
I wonder, Dr. Applewhite, what would you do in this situation? Do you think you need to go through a procedure, or is it so obvious that there's no capacity?
Yeah, to me, it seems pretty clear. That having been said, sorry, I know I'm a little quiet. To me, it would seem pretty clear, at least from this description, particularly not needing to go through a rigorous process if she needs something relatively urgently. And if we have her sister on hand who's been around and who knows and who I'm sure would have a sense of, no, she's okay to make this decision. I know her, and I can tell you that this is something that she can answer for herself, versus, a situation where maybe you don't have someone so close who's been around so long, who knows the patient so well. I think that would, number one, I think from this picture, it seems to me pretty clear.
Yeah.
I wouldn't want to break any OPWDD rules though, and so maybe there is an extra step that we do formally need to go through, particularly for this vulnerable patient population, which if we needed to do, we'd seek out and do. But I think that if she weren't someone with Down syndrome, with other sort of developmental delays, that is in that category of people, to me this would fall into the category of lacking capacity, just by clinical exam alone.
I agree. I mean, in this circumstance, I think the fact pattern is written in such a way that I think we are meant to see a lack of capacity here. I would say that there are circumstances where that lack of clarity about capacity comes up, both under 633.11, but also under the behavioral treatment standard, 633-16. And some of that comes down to the way that capacity is viewed outside of a clinical context. Or I don't know the best way to describe it, but not immediately, not when medical decision is immediate. So a lot of that may relate to the team as a whole, the so-called treatment team, being in agreement about someone's lack of capacity. And that includes the individual themselves, and it includes their advocate. And so a lot of the time when we see that lack of clarity, it's because someone on the team, because there's disagreement essentially on the team about whether someone lacks capacity. And so that's when I've seen that come up the most, where, and that obviously leaves room for individuals to object to that determination, or to family members to object to that determination.
It also struck me that, go ahead.
Sorry,
please.
sorry. I think that's such a good point. And this is, if I were talking to a bunch of medical students, where I would sort of refocus them to think about the culture that they want to create when they're running their own service, when they're running their own team, right? Because if I'm the attending physician and I create a culture where my trainees, where the support staff, where people feel intimidated by me, that I might be angry if they disagree with me, or that I might throw something at them, or that I might generally treat them poorly if they didn't agree with something I said, they might not feel comfortable saying, no, I think she does have capacity, right? And in that sense, it would prompt a more thorough evaluation. Which is appropriate if anyone disagrees, I would think, because that's what you owe the patient. But one of the things we talk about right now a lot in medical education is sort of the culture of medicine, the culture of running your own team, and what it means to be approachable effectively, and how that best serves the patient. If you're someone who listens, who hears, who weighs things, who makes people feel empowered to speak up on behalf of the patient. So that's what I would say if I were talking to medical students, just hear from that perspective. So it's such a great point, Haldan, to say that if anyone on the team disagrees, that this is a whole sort of group sentiment, and it should be. Sorry, Robert.
No, that's okay. I was going to comment, and Haldan, tell me if this makes sense, that the reason 63311 might have a different procedure for the adult whose incapacity is unclear versus an adult whose incapacity is clear is that in the intellectual and developmental disabilities setting, there might have been 3 prior determinations of incapacity for different decisions. And there really isn't a lot of value to continuing to do that again and again when not everybody's incapacity is stable and continuous. But in this population, some people will be stable and continuous, and it just becomes form over substance to do it again. Is that?
I think that's true. I think I would agree to that in principle. I think, though, the only thing I would add perhaps is that that goes both ways, right? That I have found myself in situations where I have to remind team members or even clinicians that just because there have been previous determinations of a lack of capacity, that doesn't sort of that doesn't alleviate the responsibility of that clinician or that team to continue to evaluate someone's capacity. I think obviously there are somewhat black and white circumstances, but most of the circumstances, or at least many, are more gray. And I think we all mentioned this in some context, that people have capacity to make one decision that may not have capacity to make another. And that may depend on the nature of the decision. But I've seen it, certainly, it may be a lot easier to understand, to borrow the initial hypothetical, that it may be a lot easier to understand that you want your teeth pulled when you have teeth pain than to understand some more complicated surgical procedure, right? And so just because someone, for instance, has been found to lack capacity to make decisions related to some other medical decision, if the medical procedure itself that we're discussing is less complicated, or the decision in general is less complicated, then certainly it needs to be emphasized that the determination should be treatment specific whenever necessary.
And under 1750B, you need a specialized determination of incapacity before there's a withdrawal, withholding of life-sustaining treatment, irrespective of the other determinations for. Okay, thank you.
It's great. And I'm keeping an eye on time, and there are some technical questions in the Q&A. If some of our panelists want to try to answer those, let's continue talking about the hypotheticals. And the same question that we asked, to change it up a little bit regarding Emily. So, and I'll go to Robert again, but Emily, we remember, is our 95-year-old who, as a result of Alzheimer's, has dementia, living in a nursing home, same family and friend situation as Lisa, same cognitive decline, absent Down syndrome. How is this situation different, Robert, from what was happening with Lisa?
Sure. Well, I won't put up my handy slide chart again, but this one seems a little bit easier to answer. She lacks capacity. There's no prior decision. There's nothing here that says she appointed a healthcare agent. She is in a hospital now, so the Family Healthcare Decisions Act would apply. And you would appoint her sister as the surrogate decision maker. There's no notice. It differs from the previous scenario in that there's no notice required to any agency. MHOS is not involved. You don't need to contact the CEO of a group home or the residential provider, and she's not isolated. You got a surrogate available for her. So I think it would be handled. It's a pretty familiar scenario in the hospital context or in the nursing home context.
Thank you. So, and Sheila, I am guessing the answer to the final question is the same. The reason that there are more layers of protection is this is a more, Lisa is from a more vulnerable population. Is that right?
Yes, that's how I would answer that question.
But it does raise an issue that I've debated with Sheila a lot of times. Very often I will hopefully turn her around eventually. But the 1750B and the OPWDD process here for getting a decision, there's a slight difference on the determination of incapacity. There's a slight difference on the surrogate list. There's a slight difference on the medical criteria that has to be met. There's a slight difference on the surrogate decision-making standard. And I keep arguing all that stuff trips up staff. Some of it has a good rationale for it, and a lot of it does not, or could be ironed out and standardized between the two populations. And there is a need for safeguards for the intellectually and developmentally disabled population. So there is a role for MHLS and for the OPWDD or the group home director that you wouldn't have otherwise. But apart from that, I've been a big advocate for ironing out the little differences between the statutes so that if Dr. Applewhite was an ICU physician, she would be able to treat everybody there the same standard, even if that 10th patient is from a group home.
You and Sheila can continue to debate that, because I suspect that will continue. Let's go to our final hypothetical and get some thoughts on this. We have James, who's a 55-year-old man with profound intellectual disabilities. He's nonverbal, expresses joy or pain through expressions and manual signs. He's been living in an OPWDD state IRA when he became sick and was admitted to the hospital with aspiration pneumonia. He can no longer tolerate oral feedings and can't swallow. He had a short-term IV and NG tube placed for fluids and medications, but a decision needs to be made about the surgical insertion of a PEG tube. JP's parents are his Article 17A guardians, and they were appointed over 35 years ago. I thought maybe we'd go to Dr. Applewhite because we're in the hospital. So you're presented with this. Who would you look to provide consent for the insertion of the
Parents. Yeah, I mean, I think given that it sounds like they've been his guardians for a very long time, know him very well, and, clearly going and examining him and sort of letting him know who you are and communicating as much as you're able to with him. I think that they would be the ones to sort of make big picture decisions.
Does everyone agree?
Yeah.
I would just mention, Dean, that it's interesting, you're in the hospital setting, and we haven't really talked about this, but right at the beginning of the Family Healthcare Decisions Act, there's a provision that it really sets you on different decision-making paths depending upon the law that applies. So those initial judgments are made, the person has come from an OPWDD environment and has an intellectual disability. So the Family Healthcare Decisions Act will lead you to 1750B as the statute that would govern surrogate decision-making here. And I would agree with the doctor that certainly we have a guardian here, which is in terms of the priority of surrogates is right at the top.
The only thing I would add is that it would be important, just because the hypothetical doesn't mention it, but I think we can presume it. It would have to be a 17A guardian of the person, right? Because even though 17A guardians are plenary and can't really be tailored, or at least most of the time aren't tailored the way that Article 81 guardianships are, there are still two types. And so one could be appointed 17A guardians only of the property, which would not necessarily give the parents decision-making authority under 1750B. However, because they are his parents, presuming that they are actively involved and that there's no one else that would supersede them on the list, they would probably still be the 1750B surrogates, even if they were not guardians of the person.
So in full disclosure, I had no idea there were two different types of guardians. I think that if someone came in and it was a friend who was the guardian, in this case, it wasn't parents, but it was a friend, but it was, as sort of you're pointing out, Haldan, I'm learning, like a guardian of property. I'm not sure that many people in the hospital, or at least clinicians, would see guardian, they'd be like, sweet, we'll talk to the guardian. You know what I mean? Yeah. I think that's lesser known on my side.
It's more complex than even that, because if you look at Family Healthcare Decisions Act, for instance, the highest priority surrogate is if there is an Article 81 guardian who has authority to make these kind of decisions. So you really got to run to the guardianship order and see what authority that guardian has to see if they make the top of the list. They might be a guardian who is even a guardian of the person, but doesn't have that authority. But I think more and more we see judges use a standard language and giving them that authority on for an Article 81 guardian. But yeah, we're making your life miserable. There's no question about it.
Something else, okay?
Well, I mean, and it gets even more complicated than that, unfortunately, too. I mean, I agree, Robert, that Article 81 guardianships, really, you can't make a determination unless you see the language of the order itself. Right. And to some degree, that's true with 17A as well, because you have to at least see that it's a guardianship of the person. But I think more and more, because there are somewhat tailored 17A guardianships out there, it's worth looking at the full language of the order just in case. But it gets, I encounter even other perhaps more obscure circumstances where the term guardian is thrown about. And I have to encourage staff members who reach out to me to sort of verify someone's guardianship, to say, let me see the paperwork, because we encounter out-of-state guardianships that were never transferred to New York, so that those guardians actually don't have any authority in New York State. They may have a Massachusetts guardianship that could be transferred conceivably, but hasn't been. We also see plenty of parents who consider themselves guardians because they were the guardian until the age of majority. And so when asked if they're guardian, they say, sure, yeah, I'm guardian. And that's especially heightened when there's been any kind of family court proceedings where they actually had to be declared guardian before the age of majority, right? Because that term is amorphous, especially for a non-attorney, and why wouldn't it be? It's
a memo to Rosemary Bailey, who worked on the power of attorney laws in New York, as well as the Article 81 guardianship. you should have in the guardianship like a check the box with standard powers that they have in the powers of attorney, so to at least make it easier to verify that this guardian has medical decision-making authority.
And with that, we are at the top of the hour, and there's so much more that we could discuss, but I really want to thank all of our panelists. I think we all learned something from each other, and I hope that everyone in the audience also learned lots more discussions. Sheila Shea talked about let's look upstream, and let's do that for the vulnerable people that we work with, and let's look upstream for the next set of discussions that we'll have in this series. Thank you all so much for this, and thank you to the GLC for putting it on, and Judge Stein and Rosemary Bailey. What a great panel. Thank you.
Thank you.
Thank you.